Mr. Reinsch, welcome to Constituting America's Constitutional Chats. We'd love to have you give us just some opening comments on our topic today that we've entitled Lady Justice. So I'll let you take it away.
Lady Justice, the first thing that I wanted to mention is justice itself. Justice being one of the four classical virtues, as opposed to theological virtues, known to reason, known to human logic, that is an understanding that we can come to of how we should act, how we should behave, and that our actions and our thoughts are not relative, they're not arbitrary, they're not given over to power or to emotion or to sort of there's chaos in the world, so maybe you should just try and get as much as you can for yourself. No, classical virtue, whether it's justice, prudence, temperance, or courage, presupposes there is a right order of human action, and there is a way that we should conduct ourselves. Now, there's context, and it's dependent upon context. There's no geometrically right answer in every situation, but justice is the notion that we can find what is due to other people. We can find what is due to others, and that is both commutative justice and distributive justice. They're two classic notions. We've had a modern idea in the 20th century, 19th and 20th century, of social justice. And I would submit that notion is largely derivative on a classical standard of justice, but it's just trying to impart some sort of egalitarianism. But Lady Justice would be the notion that within a government, within a lawful governed realm, and this is very important to our country, a constitutional republic built on equality under the law, built on there are no aristocracies in America, there are no classes in America that have a higher standing in the law. There's not supposed to be any race that has a higher standing in the law, nor is it supposed to be man or a woman over the other, but that there is something essential about human nature that is evinced in what we believe and how we want to conduct ourselves. So it's not surprising that when you go to the United States Supreme Court, you have three representations of Lady Justice. You have one on the outside that we're all familiar with. As you walk in the main doors, to your left will be Lady Justice, and she is holding in her hand another depiction of justice. And you've got this notion, you've got the scales, and not necessarily in that large depiction in the Supreme Court, but you've got the scales, you've got the blindfold, and you got the sword. And that should all bring to our mind, right? If I've got a blindfold on and I've got scales, then I'm willing to weigh the evidence. I'm willing to use logic and reason to come to a decision. But I've got this blindfold on. I'm going to be blind to power, to interest, to whatever might interfere. But I've got the sword. I've got to be able to execute my judgment. But that's got to be power restrained and refined and executed according to a promise, that being the Constitution. So I think those are crucial things, really, to keep in mind. And, I think this is very powerful. I was alluding to this, just thinking about our constitutional order. If you think about our Constitution, when the justices are making a decision, it starts with, we wrote the Constitution down. And so that should spark a question. Is there a value in writing things down? And so we did that. And that is supposed to give our judges, our justices, a standard. They might disagree on what those words mean or what the intentions of those words or the understanding of those words by those who drafted, ratified, and approved them. But that's supposed to be where we start. And that also is a way of being blind, in a sense, to the parties before you. And also this idea within our constitutional order, separation of powers, right? Publius in the Federalist Papers is very clear. What's the definition of tyranny in a modern republic? He says it's to hold all the power in one set of hands. So the judicial, judgment, execution would be the executive branch, and deliberation and reason would be the legislative branch. If you hold all of those in one set of hands, he says that's tyranny. And so, again, coming back to the blindfold of Lady Justice, You can't be a judge in your own cause. That's a notion of separation of powers within our constitutional order. And that's what that separation is supposed to evince. Also think about, Publius and in the wonderful essays in the Federalist Papers on the judicial branch. Famously, there's the observation: the judicial branch does not carry will, carries only judgment. It carries only judgment, and it can only strike a law down when it's in violation of the manifest tenor of the Constitution. So we should think about Lady Justice not just it's rooted in classical virtue. It has something that goes very deep back to the Greek world in terms of thinking about law. It's also in the Roman world. But in a modern republic like the United States, it should also help bring out these crucial aspects of our Constitution, of our citizenship, and what it means, what it's going to mean to be a constitutional people in our time.
Well, thank you. That's a great overview. And I know we've got a lot of questions lined up, so I'm going to go ahead and toss it to Tova. And Tova, I'll let you take it away.
Yes, that was a great overview. I have lots of questions, but I'm going to start with a sort of broad philosophical one, so answer it however you see fit. You talked about justice as this idea of upholding what's right and wrong and holding people accountable. But how do we as a society derive just laws if there are people who might have differing values of what is moral and what isn't moral based on different religious or value systems? And then how do we hold people who may not subscribe to our value or moral systems to laws that society has imposed?
Yeah. So taking Tova's question, I think the place to begin with is the constitutional order itself. And when you look at that constitutional order, it looks at human nature, and it's skeptical. It's skeptical about human nature, the ability to know the good in a political sense, and then coerce it against other people. It also, that same constitutional order, makes a judgment that we can have some confidence in human nature to know the good and to enforce it against other people. And I would submit there's wisdom in that seemingly contradictory notion, which is it's in Madison, it's in Hamilton, it's in the Federalist Papers itself, that we're in a paradoxical situation. We can't be anarchical, and that's largely the judgment about the Articles of Confederation. It was anarchical, it was too decentralized, and you couldn't come to any set of agreements about any important things like taxes to help fund our debt, which was rampant after the Revolutionary War. At the same time, you can't be consolidated in an authoritarian sense where there's no room for dissent and there's no room for different understandings of liberty. So the two structural principles of the Constitution, one, federalism, which is designed to remove heat and stress from our system by allowing, and we move away from this, by allowing as many things, and there's reasons for that, I understand, some are good, but it's designed to take a lot of cultural decisions and moral decisions and place those in the hands of the people closest to them and not have them be decided by the federal government. The other thing is separation of powers is designed to ensure that Congress is the place where you have to go to enact laws, not just get an executive order through the president, which can be easily achieved, easily waved aside, or get 5 justices to agree with you at the Supreme Court. Congress implies what? You've got to produce a consensus to reach a law, not even just a majority, because you've got to have the Senate. Senate has 2 representatives from every state. Wyoming has the same as California. When you think about all of that together, you've got to achieve not just a majority, but you've got to achieve a consensus to pass laws. You've got to do it through deliberation, and you've got to do it through compromise. And that is the answer our constitutional order gives you. Now, if you're going to make a judgment that, law itself implies morality. Our constitutional order implies a certain standard of morality about how we're going to live together. The rule of law presumes that our wills have to be checked by impersonal standards. Those are all moral notions. If you want to take a sort of anarchical more relativistic approach and say, no one can tell me what to do, or who's to say what truth is and reality is, where our Constitution says that's absurd. And that begins in the Declaration of Independence, which makes a fundamental judgment about the equality of human nature. So I think that's, the constitutional standard is rooted in skepticism and faith in the human person as to how we achieve our laws. So that's not deeply satisfying, maybe according to a modern philosophical sense, but I think the order that we're given in our system has a certain consonance with human nature that we should take pride in and defend.
Yeah, thank you for that.
Thank you for that good question.
Appreciate it. And then I was wondering if you could talk a bit more in detail about the intellectual roots of this idea of judicial impartiality, and where the founding fathers were inspired from when thinking about this idea, and then basically how this vision of judicial impartiality, contrasting it from maybe other systems, because I think it's so ingrained in our system that we can sometimes view it as a given, but it's not. Yeah. So talk about what the alternatives are.
Well, I mean, a book to read in this regard is Philip Hamburger's book, Law and Judicial Duty. And he argues that judges of the early American Republic really took their understanding for what they're supposed to do from English judges. And if you heard this phrase, law of the land, what's the law of the land? That was the disciplining rule on English judges, that they could not contradict the law of the land. They had to bind themselves to it. It may be under force of circumstances, changes, etc. Over time, they were discovering a new reason or a new rule for a new law, a new precedent, a new holding, but that had to emerge over time. So Hamburger argues that's judicial impartiality. And that's sort of how they would have understood their judicial duty. I think, the idea of a written constitution is those, and you don't really see early in the 19th century, we don't really see a lot of decisions, what we would say is sort of contradicting or overturning the will of Congress. They overturn what certain states do, and that's a source of early controversy. The biggest decision early on in terms of which was major was Dred Scott, where they bring in this idea of substantive due process to rule that you could actually bring a slave into federal territory and it couldn't be contradicted by the Constitution. That's something new. That's a new judicial standard and many would argue that's sort of what a lot of jurisprudence becomes in the 20th century, is sort of a progressive understanding of certain constitutional terms and orders that give them greater modern philosophical import than they really possessed, like using the due process clause to mean things beyond just, did you receive due process of law? So I think that the judicial impartiality, what it presumes in our system is you can call balls and strikes. And not that that's going to be perfect or easy or always identifiable, but that's the ideal. You could call balls and strikes, and you have largely the United States Congress that possesses basically the constitutional powers to run the government. And that's where the action is supposed to be, and that's where you should sit in judgment. So that's, I think, kind of maybe an overview of how to think about that. It is also a presumption that writing things down binds us better than the alternative, like a Post-it note constitution or something like that. You'll notice, many states after the United States started trying to write things down, but it didn't always work. So you've got to have writing things down, but you've also got to have that internal duty and morality of the constitutional actors to enforce it.
Got it. And then can you talk a bit about the other systems in the world that might not have judicial impartiality? Like what are the...
Well, if you just to take a page out of the headlines, right? What's going on in Israel right now? It has, and there's a lot. I think this is one controversy of many inside Israeli politics, which I don't presume to understand, but Israel does not have a written constitution. They are largely, it is said by many, progressive and conservative, they have the most activist judiciary in the world. They are largely a sitting constitutional convention within the Israeli system and have intervene in Israeli politics tremendously. And so that's a system. Famously, our English, nation of the English constitutional system that produced, how many countries come out of England's constitutional order. England does not famously have a written constitution. They have an unwritten constitution that is put together by historical precedents that Parliament itself can remake at will. And so they have brought in certain elements recently of our constitutional system in terms of their judicial branch. Recall during the Brexit controversy, it was England's judiciary that threw the whole thing almost in doubt with one judgment. So the English system is precedent, and over time, major instances of constitutional division and conflict, and plus what Parliament happens to be doing at any given time. That's a very different system than the one we're in, and yet somehow it still works. It still has led to a tolerable system of liberty for them.
Thanks. That's fascinating. I didn't know that much in depth. And then my final question for now is, what are the structural mechanisms to ensure impartiality in our legal system? For instance, if the judge does violate this principle, does judge found to have given corruption or judged someone based on race or gender, what are held accountable?
So, I mean, in terms of standards in the Constitution, if a majority in Congress, or I should say a supermajority, were to find that certain judges, particularly say the Supreme Court or the Court of Appeals, had violated that standard, even egregiously, which we had a judge impeached in Florida, I want to say 20 years ago, for taking bribes. So something like that, right? We all say, oh, you should be impeached for that. You should actually be removed from office. If a judge, if we say, well, you're actually being incredibly political and reading the law wrongly. Well, so another standard is still veto. Not veto, it's impeachment. You could defund federal courts. You could remove these if like we don't like this circuit for what they keep doing. Well, you could defund the circuit if you wanted to. You could alter their jurisdiction. What cases could they actually hear? So Congress possesses tremendous power over the judiciary, should it want to use it. Historically, in our country, it has not. And even if you think about the last 70 years in American politics, which have been dominated by debates over the power of the judiciary, that power was never really exercised. It was hinted at, it's been hinted at various times. There was, during the heyday of the Warren Court, there were certain Republicans that wanted to impeach Justice Earl Warren, but that never actually went anywhere. Where it seems to have manifested itself is, I think I would argue that those sorts of judicial decisions lead to a politics of the Supreme Court, who's going to be on the court, and it tends to shape our politics that way, which I don't think is very helpful. And those are, so it seems to be that's where the mechanisms come from. I think it's really, though, apart from constitutional mechanisms, I think it should be something within the judicial branch itself. It should be a code, custom, a culture of what is our role and how do we best fulfill it. But that of course clashes with, or I say clashes. There are also other norms that come in and other political and ideological concerns that intervene too in our politics. That make that difficult. But that my answer would be, it should be internal, and it should be a recognition of what we're supposed to do, so that we don't get to the point where we're going to have judicial impeachment trials or things like that.
Right, I can see how that could be a slippery slope in some way. Well, thank you so much for your answers, and I'll pass on to Joel and Jordan.
Hello, thanks for this deep show so far as we contemplate the depth of justice. So first of all, could you tell us a working definition of justice?
I mean, Aristotle's definition of justice is rendering to each person what they are due. Now, that's not very substantively satisfying. It's a formal definition, so it's, and that is to say, reaching into every situation and knowing the correct answer may not be immediately evident. But it is to say, we can look at persons and so there's, right, you think about the context, right? A market context. If you were cheated out of a deal by a seller who hid something about the product they sold you, there would be a certain amount of justice you should receive there. Maybe you're made whole and you get your money back. Maybe you get a product that is now put together correctly. Think about political justice, or in the sense of, you are treated unfairly by the government on the basis of race or the basis of a class designation that was attributed to you arbitrarily. So you could be potentially made whole in some way. So that's what I'm getting at when I think about justice. And that is to say, as Americans, what we have tried to do, and it's ongoing, obviously, is look at the human person. What does it mean to be a human person? What does it mean to have reason and will and the ability to deliberate? That's the source of our equality, not necessarily what you can do, not in how much money you can make or what your value to an overall market system is. We're all going to have different values based on talents and what we like to do, things like that. That's discussed by Madison and Federalist 10. But what we are going to be equal is in our liberty under the law. Ideally so, even though we have breached that many times over. So I think that's the sort of the content of justice. And it's political, it's constitutional, and it's also supposed to be something that's within our overall civil society. That is, civil society being church, neighborhood associations, groups we belong to, things we do apart from the government largely. And that itself sort of it presumes sort of a democratic equality of citizens, that we do things together with one another, not that we do things because we're ordered to. We do things voluntarily. So I think that's like the kind of the rich tapestry of justice in America. And of course, what makes that difficult is we've gotten things wrong so frequently throughout our nation's history. But I think the standard is good. And I think one should just keep appealing to it and trying to make the country better that way.
I do think that it's good to define, as you started off with that Aristotelian definition, because it will expose different ideas that would then be opposed to what the founders saw as justice and what our system was set up on, even though it may not, you still have to work in some instances to apply the definition. To render to each man what is due is different than what we may assume we're thinking of as justice. So I know that Jordan had a question kind of related to that.
Bouncing off of the definition of justice, could you put that up against what is fair? So what is the difference between fair and just?
Well, I mean, when I hear, I think what is fair, what is just, does fairness admit of an imprecision thought? And that is to say, fair could be the same as justice in some sort of semantic sense. I wouldn't disagree with that. I think with justice and that term being so strongly tied to virtue, it presumes we can actually deliberate, build on experience, and use our reason and logic to come to an answer that isn't either arbitrary or rooted in a sense of, well, I want this. I want someone to pay this for me or do this for me or give me this because. And justice is a sense of, well, it's rooted in human nature. It's rooted in the activities that we engage in. And we're trying to understand what's the best way to protect the human person and to ensure that as we engage in all of the things that make up our lives within this country, that we are trying to do so in a way that is not arbitrary and is conducive both to liberty and also to the responsibility we have to one another. So I'm just, I don't want to put my cards on the table, but when I hear fair, a lot of times what I feel like I'm hearing is I want something the way I want it, and without regard to responsibility to a greater order, and also to basic notions of responsibility, which may involve we don't get what we want, and that's something right now I think as a country we're having a hard time accepting throughout.
Yeah, and sometimes fair may be used as a placeholder for equal, and that is often will be opposed to justice because each may not be due equal in a situation. I think that we will see that word creep in when in any like bureaucratic situation. You see it like in schools a lot of times. It'll be that the excuse for doing something that's really not just to every student will be, well, it's fair because we want to treat everybody the same.
No, I think that's really, I mean, I really liked your answer just now. That notion of what is actually due to the person, and it may not be the same for everyone. I think that's exactly right. But it may not be the same for everyone, but that's got to be under standards that are logical and reasonable to people, and not arbitrary. So I appreciate that.
And I read a story. We had a literature book that was from like the 50s, and in preparation for this show, I was trying to find it. It was a story. It was something like, I couldn't find it, but it was something like Lady Justice is blind, but she's like peeking under her blindfold. It was something like that. And but the point of the story always stuck with me, of that story. And the point was that, coming back to almost a theological point, was that there is in our life justice. You need justice and mercy, and without either one, you have cruelty. You can't have mercy without justice, or justice without mercy, and both will end in cruelty. But it seems like today, can you say something about that, and maybe how that
there's
allows us to speak to other people who are seeing justice as cruelty?
There's a great book by a professor at Georgetown University right now called American Awakening, and it's about identity politics. And Joshua Mitchell argues in the book that as a country we want supplements to be substitutes for substance, and so judgment and mercy. And what we all want is mercy. We don't want judgment, and we don't want justice. And mercy can only come about through actually knowing what people are due. And sometimes within knowing what people are due, you can see a certain amount of mercy that might be given people. Within the common law order, there were courts of equity. There were courts of equity in this country too. Most of them are gone now. But the idea of the court of equity was following the laws in this limited context might lead to an unjust outcome. So we would exercise equity a little. The judge would have some equitable discretion there. But yeah, you're right. That only presumes that we actually have clear standards to begin with, and sort of this notion of mercy might actually be building on sentiment and sort of a sense of the fairness earlier, or I just want to be a decent, kind person. But maybe what you've got to do is render a judgment here to help us understand what the entire system requires of us. So I think that's entirely appropriate. If you think about a theological context, right? Mercy comes at the other side of judgment. Certainly within the Christian tradition and within the biblical tradition, and it's a good way, I still think, of thinking about this concept itself. So good questions.
So and getting to the kind of like the more in the application of the justice, and getting back to that image, which I love, that statue really of Lady Justice. She is blind to things that would cause bias, blind to what was, like you had said earlier, to class, blind to race, but not blind to the situations of the case, not blind to what is rendered to each person in the situation. So it's like because I don't want anyone to be then confused of saying, so if it matters, our justice system takes into account your relationship with the person that you did something to. That's not blind to that. It takes into account many things. What it doesn't take into account is something that you could see as a bias. So it doesn't ignore truth, doesn't ignore circumstance, but it does ignore only what should be out of the court,
Right.
which is that blindfold.
But I think the blindfold is, as I was thinking about the blindfold, it's maybe the unfavorability, the popular unfavorability of one of the parties to the case, maybe the overwhelming wealth of one of the parties in the case. If you think about John Adams representing, right, the British soldiers after the Boston Massacre, that was certainly not a very popular one, but he also thought that was his duty as a barrister at that time. So I think keeping that straight is what matters. And certainly facts matter, the facts of the case matter, and the law matters, and you've got to put together a synthesis between those two things. But I think that's very well stated. And then, also in the Supreme Court, if you're in and you look behind spectators where they sit, there is another relief, and that's Lady Justice, and her head is squarely facing evil in a battle of good versus evil. That's a very powerful way of thinking about the judiciary as well, and what we would come to if we do lose the rule of law, and if we lose that concept, then there's no law. There is, and I'm cliche. I love to repeat the scene from the movie about Thomas More, A Man for All Seasons, when he's facing his nephew, not his nephew, he's facing a family friend who wants to cut down all the laws, to get at his enemies. And he said, what happens when the devil comes after you and you've cut down all the laws? That's what that's getting to, I think. And if we do that, and there's not only the rule of law, but then the norms of reverence and the duty towards it, then we're in a lot of trouble. And that's why a lot of things happening right now really matter.
Yeah, I've been amazed as I've seen just as I've gotten older, and I started to see just how much local judges, how much power they exert over everyday citizens' lives. And do you think that there needs to be, I know you had talked about earlier different ways that the Congress can hold our federal courts accountable if they so choose, even though they don't. Do you think that today there would need to be something new introduced into law or even the Constitution in order to keep Lady Justice's blindfold on, or keep this true sense of justice as meant at the lower county courts, as we've seen really big, pretty clear violations as far as going by natural law?
Well, I don't, I haven't studied our local courts and what they do. I mean, they're ultimately bound by state constitutions, and the state constitutions themselves have the same Bill of Rights. They have tremendous protections built in them. There are also constitutional violations that state courts cannot countenance as well. They're under a certain supervision of the federal government. So I'm not sure. I haven't studied that, so I don't know. There are experts in state constitutions and state judiciaries, but I'm just not familiar enough to make a judgment. It's not my sense that we face a wave of lawlessness, according to local judiciaries. That's certainly not something that I've read about or seen creeping up. But there's a sense in which that has happened periodically in American history, and my sense is we're much better off letting states over time deal with those problems. The Oklahoma Supreme Court in the early 20th century was basically bought and paid for, but they had to deal with that situation on their own. I think that's a better way typically of coming about it than the federal government intervening, which should be, in my judgment, there are constitutional reasons when the federal court should intervene, and those should be followed. But the idea of self-government and federalism, I think, implies a communication process between the states or inside a state where they should work out their own problems, unless the Constitution says otherwise.
So then, at the lowest level of the federal courts, do you think that what you mentioned before about what the power would have at the circuit courts of a house, that the power that they do have in order to reel in a rogue court, that it's there and that what's there is sufficient?
But in terms of the United States Congress,
Yes.
Yeah. I mean, yeah, constitutionally, Congress can do what it wants with the federal courts. It could close them down tomorrow if it wanted to. So they're all of that, and the different branches are all kind of like, they're situating themselves accordingly. But the constitutional power is clearly there. There's a reason why the United States Congress is called first among equals. So I think that's a part of it. Our politics would be much better off, in my judgment, the more Congress is and the state legislatures are making judgments, as opposed to Congress, unless there's clear constitutional warrant for what they're doing.
So I'm a little curious about lawyer-judge relationships. Not relationship, but the relation to each other. How can you, if you worked with a lawyer many times, how can you remain impartial as a judge? Because if I've worked with two lawyers that are on multiple cases against each other, I'm friends with one, I dislike the other personally.
Mm-hmm.
How can you fend against that? Coloring your decision.
Yeah, I mean, when I was in law school, this is the idea of being home cooked, at local courts. But that's a lot of rules of court to deal with that as well. I mean, human nature, we're relational, right? So we work with the same people. We sort of assume things about them. We like working with them, maybe. But there are rules of court in local courts and federal courts to deal with that situation. As well. So don't discount those. I mean, like, if you bring a case and you pick the judge as a lawyer because you like that judge, many times the opposing lawyer can kick it into a different court. That requires being a good lawyer. But there are ways of dealing with that. Not that they're always used, but yeah. There's the idea of forum shopping, of which goes on all the time, is another thing. But there are opportunities for the other opposing counsel to remove and situate in a different place. So yeah, that's the way our system tries to manage that.
Gotcha. So it's on the opposing counsel
to adversarial. We have an adversarial process. So yeah.
Okay.
Yeah. All right. Thank you, guys. Good questions.
You got it. We can keep going, Kathy. You can ask some audience ones and then get back to us, or what would you like to do?
Okay, well, we'll jump in and ask a few audience questions, and thank y'all so much for your great questions, Joel.
Yeah, great answers. Thank you.
Really great. And we want to take a moment and give a shout out to our listeners on Las Vegas's KKVV 1060 AM. KKVV airs these podcasts on Monday evenings at 6 p.m. Pacific. So if you're listening on KKVV in Las Vegas, we want to thank you for that. Now, we also want to take a moment and recognize our teachers and classrooms who are watching with us today. We have Dina Patzloff with 40 students at Central Union Adult School. We have Fred Pursley with students at the Mansfield Classical Academy. And we have Hope Mucklow, Cherie Stiegel, Cammie Waynehouse, all watching with homeschool students. And we also want to give a shout out to our best senior essay winner, Lawson Barclay, that we see in the audience. And I might mention that we do have our We the Future contest. We mentioned it earlier, where students can compete as young as kindergarten all the way up through college and grad school. But we have a senior essay competition as well. So if you're over the age of 55, you might consider entering in that category. You can find all the details on our website. And thank you, Lawson, for being in our audience today. Now, we do have some great questions that have been written in both the queue, and a few have been emailed in. And first up, one of our audience members asked, how has natural law and the Judeo-Christian roots of America influenced the development of our justice system?
Well, that's a big question that can receive a very big answer. I think Hadley Arkes is a long time political theorist, natural lawyer, constitutional lawyer, who's written a number of wonderful books on this question. Anchoring Truths is one of his books. I should say First Things is another one of his books on this topic I would urge everyone to read. You know, in terms of the Judeo-Christian, I don't think that, when I think about my answer to that question, it is not that points of Christian theology necessarily shape the Constitution. Which is now a very different answer is, have people in American history changed our constitutional order because they felt called by God to do so under a divine standard of justice? Very clearly, that the answer is yes. Well, I think my answer is sort of background foundations. I mean, why did, we have our First Amendment in the Constitution, I would argue, presumes religion is good, and religion, because it's good, should be free, and you should be free to exercise it, and you should be free to exercise it without a government establishment of religion. And I can only make sense of those clauses if we assume religion is a good thing. And within, say, the Judeo-Christian tradition, the biblical tradition, the human soul is higher than the government, and it answers to an authority higher than the government, which necessarily serves to limit government. And I think over time, working out through Western constitutional history, what that standard meant was that government should be limited. And government should be limited in favor of religion, and then in favor of family. And also, I would argue, centuries before even America was created, that's what served to liberate commerce within the Western tradition and to create space for civil society, that we actually came to see the individual possessing a sacredness and a dignity that could not come from the government. It came from a higher standard, a higher purpose, and that being God. The converse to that would be, right, the polis of the Greek world, and also of the Roman world, of the empire, where the government answered all such questions and really presumed to speak authoritatively and, in a sense, for your soul and for your life. And that simply just doesn't work anymore, really, after Christianity. Alexis de Tocqueville and Democracy in America, another book I recommend, I think it's the best book ever written on American democracy, says that the principle of human equality, which you see in American politics, only makes sense, he argues, because of Christianity and because of the incarnation. As he says explicitly, God came to earth in the form of man, and that forever changed the way human beings understood themselves. So in that sense, I think the Judeo-Christian tradition has shaped our constitutional tradition in profound ways. We are, it's, I think, not for nothing that we had a tremendous movement against slavery in this country, led by various Christian men and women, many of whom suffered greatly for that. But we also had another tradition of people using the Bible to defend slavery, and that was a profound argument that happened. But then, ultimately, we answered that question authoritatively. And, the example of Lincoln's statesmanship in that regard also, although Lincoln is certainly his Gettysburg Address and the second inaugural, I don't think could be written without his having deeply read the King James Bible. But those are also ways of answering these questions about the human person that, to me, are inexplicable without the biblical tradition. So for all of those reasons, I think it's been incredibly, very, very influential in shaping who we are, how we think about ourselves in relationship to government, and what we really value as a people, which is a tremendous amount of liberty and virtue. And it's the thing that's changed in America, I think, over the last 60 years is we got a false notion of liberty and we got a relativistic notion of virtue. That's controversial in many circles, but that's how I see what's happened to our country. That was certainly not the case for most of American history. So, the natural law, is important. It's not exactly precise and clear to me how judges have used natural law. It's certainly been a part of debates, political debates, in terms of what people appeal to justify and guide their decisions. Certainly the pro-life movement in our time has made many natural law arguments for the unborn. But I don't see, I'm not natural law being something that gets constantly appealed to in judicial decisions. There are crucial appeals to natural reason by like John Marshall, by Bushrod Washington in the early republic, by certain justices who opposed the New Deal. Justice Sutherland appealed to sort of natural law principles that he said were in the American constitutional order. And certainly the Declaration of Independence. I think the important second paragraph can't be understood really without the natural law. How that all cashes out, though, I don't really have a precise, canned answer in that regard. It's just a part of the American discussion, I think.
Well, thank you. I mean, that's a great and thorough answer to a very big question. So thank you very much. Now, one of our students, Kenyon Wanos, age 14, asks, what did you mean by Congress being able to eliminate the judiciary at any time? Could you elaborate a little bit on that?
Well, it's just a power they hold under their Article 1 power includes the power to establish the federal judiciary. And their power of appropriations means they could remove, they could defund, if they so choose, the judicial branch. They've not done that. I don't think they ever would, but they hold that power. They could use it at the margins if they wanted to. They could remove, certain portions of the federal courts that they think are problematic if they come to that political conclusion. So I just always start with that because I think a lot of people overlook where power really rests within our federal system, even though currently for the past few decades, Congress has really become the weakest branch in my judgment.
Well, thank you. And it's always fascinating to me that Article 3 is the least, I guess, fleshed out of the three branches in the Constitution. The founders left so much to the Congress in order to establish what the judiciary would look like. So then we have a question from Jill in Colorado, asks, outside of the US, do you believe there's another nation that has a better judicial system? And if so, what is it and why?
It's interesting. I haven't really studied, comparatively speaking, other nations' judicial systems. Certainly our judicial system holds a certain amount of power and prestige that you don't see in other Western democracies. Canada typically since the Charter of Rights has had a very powerful judicial branch. I mentioned Israel. But other nations, the judicial branch is not as powerful. The European Union's Court of Human Rights has breathtaking power over the entire continent and exercises it frequently. But that, of course, is to bring up a whole host of questions about self-government. So I'm not exactly sure how really to answer that. Our judicial branch is, in many respects, we see this as maybe another way to think of this, has the prestige of our judicial branch started to influence other countries in the West and what they want their judicial branch to do. That's something else. Another way to think about what's happened in this country, that the prestige is so powerful. The power is what it is. But I don't really know is my answer.
Well, thank you. And then David Morgan says, hello, great session today. Can we get the titles of the books he recommended, please? Thanks so much. And maybe if
maybe I could email them to you.
If you email them to me, I can email them out to the listeners, and we would really appreciate that. I think you made some great book recommendations today. And then one other question, sort of a follow-up question from Jill. If you could change one thing about the judicial system in the US, what would it be and why?
If I could change one thing, I probably would move towards something like terms instead of appointments for life. I think that might be a better way to go. Staggered, something like the United States Senate, something along those lines. But that might be a better way of dealing with, in my mind, problems that we see in the judicial branch.
Okay. Well, thank you. And I want to circle back here to Jewel and Jorn and Tova and see if you all have any last questions before we close.
I was wondering about how the system of democracy, or in our case, a republic, influences the idea of judicial impartiality. Does a democratic or republican system make it easier or more difficult to ensure judicial accountability? What's your general connection of these two ideas?
Well, I think that, within the constitutional system, it presumes and is built on the human person and the freedom of the human person and the equality of the human person. The recognition is somehow in the pursuit of power, people can become less than they were. People can arrogate to themselves too much power, or people sort of lose their mind and turn into a mob. And so you're trying to separate all of that out and still allow somehow a consensus and a common good to emerge through debate. And I think the judicial branch is a part of that in its impartiality, at its best, it would act to strike down instances of that public consensus violating the Constitution. And that's when it should act. So that's how it would uphold, the virtues of our Republican order. That's sort of that's an ideal of an answer. But there's nothing wrong with ideals in terms of things we work towards. So that would be my system. Instead of, is it the judicial branch's job to see itself as the enforcer of egalitarianism or something like that? That's a different understanding of the judicial system, which is also prevalent in this country right now.
Jewel and Jorn, any closing comments or last thoughts? We've got about 2 minutes left.
I think all good question-wise. It was a dense show. Thank you very much for those answers and being able to think out loud with us and not skate around anything that's difficult.
Yeah, I really appreciate that. You're very honest with your answers, and it was helpful for us. Definitely.
Thank you, guys. Thank you very much.
Yeah, thank you very much. Great show. And we want to thank our audience for joining us today as well. And we want to invite everyone back next Tuesday at 2 p.m. Eastern. And we're going to be discussing justice in our checks and balances, which we touched on a little bit today. Mr. Reinsch, thank you so much for that. You had just great opening comments and answers. And we really appreciate all the work that you do at the Heritage Foundation. And we do encourage all of our listeners to check that out. We know you're probably all familiar with Heritage Foundation, but check out the Heritage Foundation's website. It just has a wealth of information on it. So,
all right. Well, thank you very much. I've enjoyed being here and enjoyed the opportunity to speak with the students.
Well, thank you. And have a great week, everybody.
All right. We'll see you.
Okay, thank you. Bye.